Hello, this is R.J. Deacon, reading the Slip Opinion Syllabus from the Supreme Court of the United States decision in United States v. Sanchez-Gomez. Certiorari to the United States Court of Appeals for the Ninth Circuit. Argued March 26, 2018. Decided May 14, 2018. The judges of the United States District Court for the Southern District of California adopted a district-wide policy permitting the use of full restraints, handcuffs connected to a waist chain, with legs shackled, on most in-custody defendants produced in court for non-jury proceedings by the United States Marshal Service. Respondents Jasmine Morales, Rene Sanchez-Gomez, Moises Patricio Guzman, and Mark Ring challenged the use of such restraints in their respective cases and the restraint policy as a whole. The district court denied their challenges, and respondents appealed to the Court of Appeals for the Ninth Circuit. Before that court could issue a decision, respondents' underlying criminal cases ended. The court, viewing the case as a functional class action involving class-like claims seeking class-like relief, held that this court's civil class action precedents saved the case from mootness. On the merits, the Court of Appeals held the policy unconstitutional. The Supreme Court held this case is moot. The federal judiciary may adjudicate only actual concrete disputes, the resolutions of which have direct consequences on the parties involved. See Genesis Healthcare Corp. versus Smizak. Such a dispute must be extant at all stages of review, not merely at the time the complaint is filed. See Presser versus Newkirk. A case that becomes moot on any point during the proceedings is thus outside the jurisdiction of the federal courts. See Already LLC versus Nike. In concluding that this case was not moot, the Court of Appeals relied upon this court's class action precedents, most predominantly Gerstein versus Pugh. That reliance was misplaced. Gerstein was a class action respecting pretrial detention brought under Federal Rule of Civil Procedure 23. The named class representatives' individual claims had apparently become moot before class certification. This court held that the case could nonetheless proceed, explaining that due to the inherently temporary nature of pretrial detention, no named representative might be in custody long enough for a class to be certified. Gerstein does not support a freestanding exception to mootness outside the class action context. It belongs to a line of cases that this court has described as turning on the particular traits of Rule 23 class actions. See Sonsa versus Iowa, United States Parole Commission versus Garrity, Genesis Healthcare. The federal rules of criminal procedure establish for criminal cases no vehicle comparable to the civil class action, and this court has never permitted criminal defendants to band together to seek prospective relief in their individual classes on behalf of a class. Here, the mere presence of allegations that might, if resolved in respondents' favor, benefit other similarly situated individuals cannot save their case from mootness. That conclusion is unaffected by the Court of Appeals' decision to recast respondents' appeals as petitions for supervisory mandamus. Respondents do not defend the reasoning of the Court of Appeals, and instead argue that the claims of the two respondents, Sanchez-Gomez and Patricio Guzman, fall within the exception to the mootness doctrine for a controversy that is capable of repetition, yet evading review. Kingdomware Technologies Incorporated versus United States. Respondents claim that the exception applies because Sanchez-Gomez and Patricio Guzman will again violate the law, be apprehended, and be returned to pretrial custody. But this court has consistently refused to conclude that the case or controversy requirement is satisfied by the possibility that a party will be persecuted for violating a valid criminal law. O'Shea versus Littleton. Respondents argue that this usual refusal to assume future criminal conduct is unwarranted here given the particular circumstances of Sanchez-Gomez and Patricio Guzman's offenses. They cite two civil cases, Honing versus Doe and Turner versus Roger, in which this court concluded that the expectation that a litigant would repeat the misconduct gave rise to his claims, rendered those claims capable of repetition. But Honing and Turner are inapposite because they concern litigants unable, for reasons beyond their control, to prevent themselves from transgressing and avoid reoccurrence of the challenged conduct. Sanchez-Gomez and Patricio Guzman, in contrast, are able, and indeed required by the law, to refrain from further criminal conduct. See Lane versus Williams. No departure from the settled rule is warranted. The decision is vacated and remanded. Chief Justice Roberts delivered the opinion for a unanimous court. Thank you for listening.